An uncomfortable truth is emerging within the UK telecom sector. Thousands of businesses may have been mis-sold contracts that are fundamentally different from what they appeared to be. Furthermore, what started as a simple deal for phone systems or broadband has, for many, become a financial trap. This situation often involves payments being routed through third-party leasing companies which the customer never knowingly approved. We believe the scale of this issue is significant and affects businesses of all sizes, from small firms and charities to schools and medical practices. Here is how the arrangement frequently worked. Telecoms providers offered businesses new digital systems, often presenting the paperwork as a mere formality to install equipment or authorize payment collections. What many customers did not realize was that this agreement was not with the telecoms company they were dealing with. Instead, it was a binding finance or leasing agreement with a separate, third-party entity that would take ownership of the payments, often over 4 to 7 years. Once signed, the customer's bank details were passed on, and regular payments were set up to a company they had never heard of. Businesses found themselves locked into long, expensive finance deals that could not be cancelled, even when the equipment failed or services were not provided. Under UK law, a contract requires fully informed consent from all parties. If a customer was misled about a fundamental term, such as who they're contracting with and where their money is going, that consent cannot be said to exist. This is not simply a case of poor sales practice. When a customer was led to believe they were dealing directly with their telecoms provider, but payments were sent to an undisclosed finance company, the contract can be challenged for misrepresentation. Where concealment of this arrangement was deliberate, it may also engage the Fraud Act 2006. Therefore, these agreements are not just unfair. We believe many are legally unenforceable, giving businesses the right to recover payments made under them. We are aware of the growing pressure on banks, leasing companies, and telecoms resellers to explain how these practices were allowed to happen. Experience shows that when such issues arise, the financial industry often moves to limit its liability. Arguments may be raised that these were commercial agreements outside consumer rules or that customers should have complained earlier. At Meridian Legal Services, we have already begun submitting formal claims on behalf of affected clients. Our specialist team is focused on navigating the complex legal arguments surrounding these specific agreements. We prepare detailed claims setting out the clear legal basis for misrepresentation and restitution. Accordingly, we pursue the recovery of funds directly from the finance company, the telecoms provider, and, where applicable, the bank that processed the unauthorized payments. This issue concerns systemic deception that has impacted UK businesses. The law already provides the necessary tools to challenge these contracts and recover what has been taken. If your business has been charged by an unknown leasing company after signing a telecoms agreement, or you have identified payments you never authorized, we can advise you. Contact us for an initial, no-obligation review of your circumstances.